I'm Jackie Hutter. I've prepared this YouTube as a second in a series. This one specifically is how to win the patent game. It gives you an overview of my proven patent strategy tools that innovators can use to create patent applications and issued patents that meaningfully deliver the desired business value from their patent activities. I've been in this business for well over 25 years now, and I have worked with dozens of companies, hundreds of patents, and all technologies, all types of technologies, all kinds of patent strategies, all kinds of business strategies. And looking back at all that activity that I have done over the years, I have realized that patents rarely matter. That is, they rarely move the business needle that just to justify all the expense, all the opportunity costs that are expended to get them in the first place. Only a vanishingly small number of patents are really important for any company. But when they are important, they're really important. Or as I often tell folks, patents rarely matter, but when they matter a lot. If you are someone who's creating meaningful innovation, doing the hard work of bringing new solutions to customers, delivering value that was never available before, then patents might actually matter a lot to your business outcomes. Probably not in most other situations, but certainly if you're an innovator, it should be something that you look very closely at as part of your business strategy. Now, in episode 1 of this YouTube series, I talk a lot about the differences between invention and innovation and the problems with focusing on invention when you are in fact an innovator. For the purposes of this specific presentation, I'm going to just talk briefly about something that an illustration. I think it provides some guidance as to what I mean for the purposes of the rest of this conversation. So if you look on the left here, you have what I consider to be a quintessential invention. Some of y'all might remember that that there was a lot of hullabaloo, there was a lot of confusion and upset about the fact that the 2015 F-150 truck, a very popular truck here in the United States, was going to be transitioned to an all aluminum body. The expectation was that how could aluminum be strong enough to meet the performance criteria for a heavy truck that's used, in the type of things that heavy trucks are used for. And of course, the reason that Ford Motor Company did this is that they needed to lightweight the truck in order to comply with the fuel economy standards that were coming into existence at that point. And the way that the Ford Motor Company business team, technical team decided to do this, in retrospect, was through the all aluminum body. This was, I believe, an invention, because at the end of the day, an aluminum truck functions the same as a steel truck. There are really no differences in performance other than the fuel economy, and the fuel economy differences are not transformative. They're actually only incremental. You get a few more miles per gallon, which is what you needed, but there's not a different kind of fuel. There's not a step change in the fuel economy. And at the end of the day, from what I understand, the all aluminum F-150 was pretty much a equivalent switch out for the previous steel body. Now, I will say that the functionality of the aluminum that then worked like steel was very likely an innovation. That was a transformative type of aluminum, but when put into the truck, it was still a truck. Fast forward to the 2023 F-150 all-electric Lightning, which at this point, when this presentation is being recorded in winter 2022, is supposed to be released in a few months, and there are hundreds of thousands of folks who are lined up to buy this vehicle. Now, this is an innovation. Why is it an innovation? Well, not only will it take people to work sites and carry tools and provide the functionality that the existing truck truck, the F-150 trucks have had, for years, it actually also will power a house for 3 days if the power is lost. And if you think about that conceptually, the functionality is of a battery plant, a battery pack. It's a battery pack on wheels. It's a battery pack that happens to carry people from job site to job site. It's a battery pack that actually carries tools. And it has a functionality that is all new, that never was conceived of before. And gosh, would people have thought that they might have needed this? Well, probably not, because a truck was a truck in the past, but now a truck is able to provide power for an extended period of time, while at the same time doing everything a truck actually does. That's new. There's new functionality, there's new use cases, there's new ability to do things that you weren't able to do before. And so in the context of delivering new customer solutions to solve existing problems, as well as problems that now that they can do this, there's going to be a whole suite of new functionalities that are going to spur from this transformative product here. Now, I am not responsible obviously for the patent strategy of the Ford Motor Company, but I would hope that whomever was responsible for drafting the patent applications for them looked at the patenting process from this context. Otherwise, you're going to have every other company out there who makes trucks trying to provide the same functionality, and without patents that broadly cover this new, clearly new functionality, as well as any functionalities that may spring from here, Ford Motor Company is going to have a lot of competition there. And this means that if you're an innovator, that is, if you're creating and delivering new customer solutions that are going to change the way the customer acts, they behave, and what they are going to expect, you must make it cheaper to go through you than around you. And patents might very well be a way to ensure that others find it necessary to go through you. So how do you know? Let's assume that you're a startup technology company, you're a CEO. How do you know that patents matter to your innovation-based business model? Because there's a lot of countervailing stuff out there that people are, and so it's really, so if you're a non-expert, how do you know whether or not patents are going to be relevant for what you specifically want to accomplish in your business model? Are patents going to help you create the value that merit the hard work and investment that you're making in your business? Well, we need to first find out whether patents matter in the markets that you are entering. So ways to do this are, we can look at sector relevance. Of course, there's some sectors that it's assumed you're going to get patents. If you don't have patents, you're probably going to be locked out from investment, and you're probably going to not do really well overall, just because that's the way things are. Medical devices are an area where you probably should think very, very highly, very strongly about very early figuring out what your patent strategy is going to be, because you're not going to be able to exit in all likelihood if you don't have patents. There's other sectors where I'm seeing that patents are becoming more important. Certainly that's in the artificial intelligence space, in the industry 4.0 space, in the areas like that, IIoT space. I'm doing a lot of work there because it's not about just creating a solution. It's actually making your solution durable, so that you can keep others from, you can demonstrate the value to others, and patents help you do that. And we're seeing investors, VCs, being much more inclined to push patents than they may have been, say, 10 years ago, when there was more of a anti-patent bias in the startup world. We can also look at where the incumbents are laying down markers. And if it's in the space of patents, then, you know, if the incumbents are signaling that they care about patents, anybody that's seeking to partner with the incumbent or to exit the incumbent should really be thinking about getting patents, because they care, right? So if somebody cares, you probably should lean into the direction that they care. And I see a lot of the larger companies that are, you know, platform-based companies or solutions-based companies. They tend to get patents that are directed toward what I consider to be their 3 to 5 year strategic plan, new business models. They want to lay down patent markers, very broad patents, that so that they won't be kept out of a market that they see might be emerging in the future. And so if there are folks, if there are companies, large companies out there that are laying down patents that I can see that they may be interested in something in the future, I certainly want to typically advise my clients who are going in the direction of these existing incumbents to get patents that are aligned with what appears to be these large company strategies. We can also look at previous exits that other startup and early stage companies will have. I have a client right now that they've done a competitive analysis. They've done an investment, and their investors have figured out, how do we get our money back? And there's a company that was relatively young, 8 to 10 years, making a product that had a very large exit. When they dove down and to see what could have precipitated this large exit, even when the company did not have that many customers, they saw that this company had created a very large patent portfolio in a very short period of time that covered not just products that they were making, but also business models that might be deployed in the future. And so my client has hired me to create a robust and large patent portfolio in a very short period of time, because the investors have said they want out in the next 2 to 3 years. And the only way you can either build something very quickly and get the investment, spend your money on the scale to get the customers and to develop the technology in that short period of time, or you can create another strategy that gets that desired business outcome, exit in 2 years. And here they have decided that getting a robust patent portfolio is the way to get their money at the time period that they want. Also, business strategy can demand a patent. Very often I talk about patents as being technology virtue signaling. You get a patent and you can show a strategic partner, an existing company. It's like, hey, we're not just making this up, that we have some good stuff here. We can show you what we're doing, get a seat at the table and show you how we are going to solve your problems, that you have existing customers, you have existing markets, but you're not able to solve that problem. We can show you vis-a-vis our patent filing, our issued patent, that not only can we solve the problem, we also can provide you with durable problem solving, because we have protection that you may wish to align yourself with against your competitors so that they can't sell the same solution. But even if patents are incredibly important to what you're doing, if it's not the right time, then you shouldn't be doing it. Importantly, and I see this time and again, if you don't have the financial wherewithal to do this, while at the same time you are building your business, validating your customers, developing your technology, you shouldn't be doing patents. You shouldn't pay me when you're better off spending the money on validating your business model, developing your technology, and getting those customers in the door. It's not cheap to get a patent, even doing it in the way that I'll show you later. And if the difference is that you need to hire somebody to actually do business development for you versus developing a robust patent portfolio right now, you probably should hire the business development person. And just because you forego getting a patent today doesn't mean you can't get one in the future, because as an innovator, you're going to continue to validate, develop technology, create new solutions. And if you do that if you forget, not do it today, that doesn't mean that you're not going to be able to develop the broad and robust protection at some point in the future. You just have to be willing and able to revisit the decision not to get a patent on a regular basis. And even if you have the money, it's so important to impart to you that you have to have the time to do it right. You just can't say, get a patent for me in this way, because this is a business function. If your patent strategy is aligned toward a desired business outcome, then the business has to be able to provide the time, the insights, the knowledge to do this the right way. And if you don't have the time, you can't do it. You can't do it the right way. I also want to throw in here, probably this is the right place to do it, that if you're thinking about protecting your product, you're thinking about the wrong thing. Litigation is death for startups and early stage companies. If you're paying lawyers instead of developing your technology and building your business model and validating your business model, you're supporting a lawyer's business model, not your own business model. And no investor ever wants to come in and fund litigation for a startup. This is crazy talk. And don't let anybody tell you anything differently. You're using your patents, and you would do this patent strategy to develop strategic partnerships. Hey, I got something really cool. Do you want to join with me? BASF years ago had a great tagline. They said, we don't make the stuff you buy, we make the stuff you buy better. The better stuff is what my clients are doing. They're creating innovations that allow companies like IBM, they allow companies like insurance companies to actually provide their customers with the technology solutions that allow the problems to be solved. Sometimes you may be you may decide that your business strategy is developing licensing revenue that will allow you to do other things. This is not a very common strategy in the startup world, but I do have clients, particularly medical device companies or people in the medical space, that have been able to get patents that throw off licensing revenue that allow them to fund their other endeavors, and also, very importantly, can prevent them from taking as much dilutive capital as they otherwise might need to do to affect their final business strategy. But again, every strategy is different, and this is not something I would recommend assuming is a possibility until you've actually run all of this potential scenarios and say, yes, I think we can get this done. The other thing that is super important, and I've got multiple examples of this from my own client, being able, not just getting good patents that are aligned with your business strategy and the business strategy of your competitors and those in the marketplace, because that's just as important. People don't buy patents; they buy patents that cover validated business models. That if you have patents that are aligned with these business models, and you can articulate them, you can very often enhance investment and exit. And I've seen this, as I said, multiple times, and it's super cool to be able, as a IP strategist, to be able to have that conversation with an investor or a potential acquirer and say, yeah, we've got really awesome patents, and this is why we know they're awesome. And then that extra money, that extra exit comes in, and my clients are very happy. So let me give you an introduction to how I create and deploy this winning patent strategy for innovators. So first of all, these are proven. I told you in the beginning, I'm going to show you here. These are proven strategies. Okay, I have done this repeatedly for the last several years with startup and early stage clients. Now, what I will say is I had I've dealt with hundreds of patents in my career, and no one ever asked me what my win-loss ratio was. And that's really interesting because that's not something we patent attorneys are trained to expect there to be actually a successful outcome for our client. We are not trained or expected to, quite frankly, to be able to calculate when we've done well for our clients, because the goal is to write a patent, get a patent through the patent office, and the business people do whatever they want to do with their patents, if anything at all. But here, my clients hire me to get their desired business outcome. So every patent filing that I do, and there are more than I'm showing here, but I'm talking specifically about those patents that we've set out to get allowed in a very short period of time through the track 1 process. This has worked. We have no abandonments. This is not a situation where you ask me if something's patentable and I say it depends. You ask me, can I get a patent? And by the time we get the patent filed, drafted and filed, we're pretty dang sure, if not almost certain, although nothing's a certainty in this world, that we're going to be allowed, and we're going to be allowed in the period of time that we need it to happen, namely here in this basically a less than a year process. The longest patent filing pendency that I have had out of these 19 patent applications is 17 months. And that was an unusually long period of time. Most of my patents are being allowed, and that is the patent office says, yeah, we'll let you through. There's some paperwork, as a lot of folks know, that go after that, but it's all but over by the time we get a notice of allowance. And I'm getting, I've gotten a couple allowed in less than 4 months. Most of them are around 7, 8, 9 months, but it's kind of, it's really cool that this is actually working, and especially in compared to the average pendency in the patent office, U.S. Patent Office, until grant or abandonment. Has the patent been abandoned? 2.3 years, and only 52% of patents are granted. 100% of the patents that I have filed to date using this process have been granted. And lest you think that, well, I must be working in areas where they're not software, because my patent attorney tells me software is hard to patent. No, most of these, the vast majority of these that I filed would be rightfully considered to be software patents. And because we're undertaking the process that we're undertaking here, I'm going to be sharing a little bit with you in a couple of slides. We're getting them allowed without the same problems that are traditionally associated with patent filings, software patent filings. Now, I'm going to show you here is anybody who's been involved in the patent office process knows that very often you have to refile the case because you've had to make claim amendments that allow the patent examiner to push the process along and get more credit, whatever, however you want to characterize that. But I wanted to make sure that I showed folks here that we're actually getting things allowed in first action allowances. That means that, the patent office says, as soon as I file something, hey, it's allowable, I'm going to just let you through. That's not, that's fairly rare, not so rare in this process, but it's still fairly rare. The patent examiner, very often, rightly or wrongly, says, you know what, here's some prior art. I need you to go ahead and argue it. But the vast majority of my cases, 14 out of 19, have been allowed after first office action response because we take the strategy that we do. 79% of my patent applications that I filed as track 1 have been allowed after first office action response, which also, by the way, reduces the overall cost of the process because it's not being dragged out by having to file additional patent applications. Now, if patents are a key performance indicator of your business strategy, you must not only be able to get patents, you must be able to generate patents that are future-proof, that protect your future, in other words. So how do you do this? Well, first of all, if you don't have a product market fit, you don't have any real knowledge of the current scenario. Therefore, you can't have any real knowledge of the future scenarios that might have value. So if you don't have a product market fit, then it's not go time. You don't do this. Okay. If you do have a product market fit, that is, if you have taken your solution, you've developed technology, and you've put it in front of the customer in a way that allows them to give you discovery information that say, yeah, I think I would pay for that. These are the circumstances I would pay for that. Can you deliver this? And you think this is real, but early, what we're going to probably do is file a provisional application that, I'll go in most folks probably know what a provisional is. I might in a future series talk about what these substantive differences are, but what we're going to do is file an early patent, still robust, because a provisional application only covers what's in there. If you don't have it in there, you can't expect protection. So, but we're going to file the provisional to get our priority date, because we believe we got a product market fit. So if we've got a product market fit, we should file something, because we want to get that priority date in there, in that provisional. But we're going to put that optionality in there. And what we're going to do over the next year is we're going to go out there, or up to a year we have before we have to file the utility. What we're going to do is go out there and get our information in front of customers, learn more, and when it comes back around to filing the utility, then we're going to put all that additional customer discovery, we're going to put all that additional technology development information in there, and we're going to go forward with that. But if we weren't right, but if it was early and we were wrong, we can always not go forward with that provisional application, and we can go forward with and just leave that alone, because if there's no reason to go forward with the utility application if you actually don't have a validated business model ultimately. And so filing a provisional application, filing a utility after provisional application is not something you have to do. You don't want to do it unless you've got real business model validation at the end of that process. What if you have validated but early product market fit? Well, what we'll either do is file a provisional, which I typically end up doing with my clients just because it feels like a better scenario. But again, it all depends on what you want to do, ultimately from a business strategy. If your goal is to get as many patents as quickly as possible, doing a provisional is not going to do that for you. But if you are truly in the business model validation stage, probably want to file a provisional, go out and learn more, but still go forward with that priority date. Alternatively, we can file that provisional. I'm showing that utility, and it has that optionality. Because we're going to have been talking to customers, and we're going to know what problems they have and what problems that might be adjacent or through elsewhere in the value chain that are associated with my technology enablement. If we do have established product market fit, which I typically see with the early stage companies, that is companies that have revenue, that have customers, that are building very, but still early, such that they're baby established companies, I guess, if you will. What you want to do is probably just go forward with utility and include as many adjacencies in there as possible, because you don't know if your early stage companies still sometimes, fairly often have to pivot for whatever reason, competition, better opportunities to quicker time to scale. So you want to make sure when you're filing, whatever utility application you're filing, also will enable you to have coverage in those adjacent markets. So I talk a lot about foundational patent filings, and the foundational definition is something that has an application that has as many product iterations as can be identified. It's as many optionality, as much optionality as conceivably possible based upon what we know today and what we can hypothesize. It's not just what I know, it's also, now that I have done the work of customer discovery, talking to customers, seeing what customers are telling me that they need. I want to put as many of those as possible. In a more status quo patent world, folks call this an omnibus patent application. Some of my clients call this the big kahuna, because they kind of makes them think it's like everything we possibly want to own now and in the future that is in this technology framework is the big kahuna. Some folks also call it kitchen sink, so I want to put all the various characterizations there so you know what we're talking about here. How do you know whether we're going to file a foundational patent or a more specific patent? And it's a hard question to answer. For the most part, we're basically looking at understanding how broad is the suite of actual and potential business value from the tech innovation insights that we've developed. How mature are the products resulting from the insights? If going through this analysis, you basically see, oh, there's one or two products coming from this, it's probably a specific patent. But if it's something that's like, wow, we don't know who in the value chain might be interested in this. And once they see what we're doing, and we actually ask the questions, if I change this value for the customer, how will other companies in the value chain then respond to their customer needs? And so we want to understand as much of that as possible. And if there's a lot of actual potential business value, you're probably looking at a foundational patent application. The benefits of doing a foundational patent application, you get an early priority date. I've got a client that we filed in early 2016 for a business model that that our technology enabled, a specific business model. We were trying to sell into that market. We filed utility patent application in early 2017, claiming priority to that. We got a patent to that. And however, we also included a lot more things in there because we thought that this business model was something that people would be bringing us big bags of money to solve their problems for them in that business model. However, it turned out that wasn't the case at all. That was we were way too early. Even though our technology could solve the problems, the market was not ready for that solution at that time. And when we prepared this patent application, we also incorporated other customer discovery insights that we had gotten along the way. And sure enough, we ended up pivoting to one of those other areas. And that actually was a business model that our technology enabled. And we actually started getting revenue in that space, developing market effectiveness. We were actually throwing off revenue, so we needed less investment in that space. And so we went there. It was a market that was ready to be addressed, unlike the other ones. But also in that patent application, we included things along the lines of, I said to my team, for example, so once we solve this problem, what is the next iteration of customer value? And again, we're going back to 2016 here, but the team said, well, once we can solve this problem and we can do it correctly, then people are going to ask us to do it for them automatically. That is, they're going to ask us to do it using automated intelligence, and we probably will be able to do that at that point. And so we included AI in the application because that was the natural consequence of our being able to solve this customer problem. And then we also added in there, well, when you have AI, what do you have? Well, you also have augmented reality and virtual reality. Was incredibly early back then, but we included in the patent application. And 6 years later, we are still filing patent applications off of that original patent that covers not just the business models that we were we are in already, but also the business models that we continue to move into as an early stage company getting poised for exit in the not too distant future. And our priority goes back way before anybody else in the business. We had so much optionality in this application. It's almost amazing to look at it now. But that doesn't happen by accident. We really pushed ourselves to include as many business models, actual or potential business models in this application as possible, which has enabled us to continue drawing from it. And we're keeping this pending till our exit because I can tell you, not a lot of things I can tell you with certainty, but one thing I can tell you is that if you're a startup or early stage company that has a really good priority date for broad, robust, foundational patent filings, you keep that pending till exit because it's worth a lot more at valuation than a patent application family that you've let die if it was still had continued viability. Now, of course, there are downsides to the foundational patent filing strategy. It's more expensive. It takes more time. If it's more work, it takes more time. But it is what it is. If this, you will only do that if the business strategy demands that this is the approach that we take. So I don't do this by myself, as I indicated. I need the business team to help me create a business value directed patent drafting strategy. Okay. What do I need? I need business material. Okay. I need to understand how the customers are responding to the pitches that you're providing to them. Why are investors writing you checks? Right? I need to see pitch decks, marketing collateral. I need folks to tell me what the customers are saying to them. And one of the ways that folks can provide me with this information is to do a download, just an information dump via recording that I can then get automatically transcribed. And what do you know? I have a ready to go patent disclosure without you having to do a lot of work. And even more importantly, because it's done. The best way I've seen it done is I have a team that does basically an information download stream of consciousness, and I end up with some really good stuff, much better than I can, of course, generate myself from my hypotheses of not being, and especially when I'm not involved in the customer, but also it's a lot easier to do a data dump, do an information dump about intangible things like what the customers are saying to you via recording, as opposed to trying to write it down and figure out making something very formal. As far as I'm concerned, if you send me something in writing that you've made it very, very formalized, it's probably not going to be in the form needed to prepare a patent application, which is a very specific writing form. So we don't need for you to spend a lot of time writing something that I then have to rewrite. It's just not an effective use of time. Of course, I need key market player information. You keep this information. I don't know this stuff because I'm on the outside of your business, and so I need to understand who your competitors are, who the competitors are, who the people already in the market who have viable business models. This often is, at least in the technology spaces that I tend to work on, I'm seeing competitors very often, I should say incumbents very often, that are companies that were just a few years ago startups, that they have become unicorns, if you will. They have a lot of investment, but they're still not able to truly solve the problems because they need a specific set of technology solutions that they don't have the core competencies of providing as quickly as possible. So a lot of these companies that have large investment portfolios, they're able to acquire other companies, are looking for companies like my clients to provide them with ready-made solutions that will allow them to generate the revenue via real solutions that will presumably justify the investment that they've gotten. I'm also looking for you for key customer discovery insights, current, future product market fits, what is the underlying problem? And importantly, why is it not solved? There's going to be any number of patents out there in most cases telling me how fabulous somebody else's product was in the past. And if the problem still exists, these patent disclosures, these previous solutions didn't solve the problems. So, if the problem's still there, then you tell me why it's not solved. I can go in and make a case of why these patents that ostensibly should be prior art are really not prior art. And this is just as important. How do we solve the problems in a new way that matters? Okay, we're not doing this just to do the work. We're doing this because the problem's there. It's big enough that we understand that there's enough money to be made for everybody involved in the process if we can execute on this. And we're doing it in a way that really matters to not just the customer, but other folks potentially in the customer value chain. Of course, we want to do adjacent market analysis. What might we be doing in the future if this doesn't pan out? And also, how might third party view our insights? Because we're focused on our product market fit, our customers, and we need to also create this parallax point of view. We say, well, there might be other folks that see something different, see other opportunities, and this is a really important situation here. And I'll just mention this about a client that we were able to get patents very, very quickly. Really awesome patents. They were killing the market, a new AI solution that was really streamlining a really important analysis product, really critical way to analyze something as quickly as possible. They were just killing the market. Customers were coming, in the door as quickly as possible because our solution made them lots more money. And then what happened is that our biggest competitor was bought by a billion-dollar company, and their product, the competitor's product, wasn't very good for that matter. But it probably doesn't matter at the end of the day, because the billion-dollar company is going to be able to create the marketing ecosystem for our biggest competitor that's going to make it very difficult for us to compete, even given our superior product. And so what we had to do is go in and pivot into an adjacent market. And fortunately, as will happen in this process, our patent application also covered the adjacent market, because our technology, our technology enables multiple problems to be solved. It's not the technology that we're protecting per se. We are protecting the problems that our technology enables to be solved. So how do I get these patent applications allowed with pretty easily, without what I consider to be legitimate examiner pushback? First of all, innovators, what they're doing is by definition patentable. We typically ask, is something, as a patent attorney would say, is this novel and unobvious? And we go down the analysis to look at the prior art and to see whether we're different enough over the prior art. Do you get a patentability opinion? No, we don't have to do, literally, we don't have to do patentability opinions here, because what we're doing is novel. We're solving a problem that has never been solved before. And it's a big problem, because if it wasn't a big problem, we wouldn't be throwing all this time and money against it. And so by definition, then it's unobvious. So the question then becomes, how do I draft claims that are easy for the examiner to allow, and that create the maximum value for the business? So what we do is what I call designing applications for allowance. And I did a podcast episode on this in the series, season 1 of my podcast. So you might want to, if you're interested in this, go into a lot more detail there. But we draft the application and the claims as patentable over the prior art as written. We don't have to look at all the prior art, but the prior art gives us signals, it gives us patterns, and we make sure that what we provide to the patent examiner is are allowable. Our claims are long, but they're very broad. There's nothing that limits our claims. And as an aside here, I find it's very fascinating in kind of an ironic sort of way. There's an understanding, conventional understanding, and conventional wisdom is never wisdom because it's conventional. So I'm providing you with this is real wisdom. There are software programs. There are people who do analysis of patent portfolios for a living. And one of the metrics for how valuable a patent is how many words are in a claim. And with the assumption that the longer a claim is, the more narrow it is. That's absolutely not the case. If everything you put in a claim is non-limiting, then it's broad. But what you do in this case, in this scenario, is that by having long claims that are broad, you eliminate most of the prior art from examination. The examiner, quite frankly, can't find prior art that's relevant. And so we get to argue in a more focused manner if we do get that rejection, at least in the first office action. And also super important here, one of the reasons why I'm able to get most of my cases allowed after first office action, and hopefully won't go to too much geek world here, but I want to make it so that the examiner cannot legally, or legitimately, I should say, issue a final rejection that requires me to jump through all the procedural hoops that take more time and cost me more money, neither of which is optimal or actually desirable in any way, given this is a strategy. We want to get quick and easy allowance of broad claims under this strategy. So we, instead of thinking that if I get a rejection, I'm going to go into the application and add new subject matter. That's not what we do. We actually put that subject matter in our dependent claims so that when I get a rejection from the office, from the patent examiner, I'm able to amend the claims in a way that should not give rise to a rejection that requires me to start the process all over again. And I add, because I'm very strategic about the things that I add to the dependent claims, I'm able to add claim amendments to the case to get it allowed, to the independent claims to get it allowed, that are not limiting, but the examiner thinks that I'm giving something up and I'm relinquishing protection. And so they're going to be more inclined to allow my case versus doing it in another way. So this is a little understanding of my process. What I do when we engage and I get started on the drafting, I review the prior art. I look at the patents, of course. I don't look at it from the standpoint of is patentability opinion, because remember, we are patentable. So so I started a different place. But I want to know how people have solved the problem, if at all, or sort of purported to solve the problem in the past. And sometimes there may be just a few patents and some more modern technology. Sometimes there may be dozens, if not hundreds of patents, depending on the area in which I'm working. But it really doesn't matter how many patents there are, because the patents show you how people have solved the problem in the past. And the problem still exists because everybody's solving the problem in pretty much the same way. So you get pretty quickly, you get breadcrumbs, and you get to be able to tell the story about why the prior art doesn't solve the problem that your client's technology solves. We also want to look at competitive analysis, not just in the patent world. I want to understand what other folks are saying in outside of the patent area, because that helps me understand how to frame the business focused, the marketing information that other folks are saying, that is separate and apart from patents. Patents, of course, are very specific to what their objectives are. So we need to look at other types of information to get the best scope of understanding of really what we need to be talking about in order to get the protection of the business cases. Also, this is not for every technology, but it's for a lot of technologies that I'm dealing with. I can learn a lot about why the problem is not solved by looking at the more recent academic literature. If you think about, you've got academics who are getting in, writing 400-page dissertations on a very specific problem, that's a pretty big problem. And I'm not reading the whole thing, but I'm just understanding, I'm gleaning from these academic literature and articles, technical articles for that matter. Review articles are awesome to tell me, how we are where we are in a world where the problem's not solved. And we get to find really good, very often the academic literature gives us the ability to tell the patent office, like, hey, you got all these people, and just 6 months ago, they were saying this is a big problem. My client's solving this problem. So it helps you build that story together. And what I do with this information is I synthesize it to create the maximum potential to create to the business value. I help you collect and present the information in a way that allows you to be the lexicographer. It allows you to best define your, that's a term of art in the patent world, but allows you to define your invention in the best way that creates the maximum business value. My job is to help you define the coverage that gets you the desired business outcome. Of course, we're going to discuss and collaborate. I'm going to confirm that the proposed coverage aligns with your business strategies, right? What are you trying to do? And is what we're doing, how we're going about it, going to help you make that happen? We're going to incorporate additions, corrections, and enhancements. It's a back and forth process. And again, it takes time. And then we're gonna draft the applications and claims so that they'll be allowed. I'm not filing anything that I don't have utmost confidence that is allowable, not just in the specific claims that are being filed with the first application, but also that appear to be allowable if we need to pivot and if we develop in the way that we think is going to happen in the future. I do this by telling a great story in the background section. Unfortunately, there are so many folks who are senior people in the profession. I know because I worked with them for many years, who were taught to not talk about the prior art, to not write a background section, and to just throw claims in the patent, draft a specification and claims and see what the patent office says. That's not the way to do it, in my view, because that puts too much risk and uncertainty in the patent process. I want there to be to eliminate as much risk and uncertainty as I possibly can, because again, my clients are getting these patents for a reason. And I need to be able to give them as much certainty as possible through the patent process. And this is how we do it. The specification, of course, because it will have many iterations and demonstrates the improvements of the prior art. Again, talk about the prior art. That's, conventional wisdom is not wisdom because it's conventional. We talk about the prior art. We talk about why the prior art does not solve the problem. And again, we draft claims so that they are allowable over the prior art as they are written when we file them. So there's a lot of work here, and I have to say that for a lot of these patent applications that I did, and I still continue to do, I found if people really knew how much time it took, they probably might have some reservations about hiring me. But at this stage, as successful as I've been, and for those companies that this is, getting patents is a key performance indicator of successful execution of their business strategy, I've got to be upfront with you. This is how long it takes. Of course, I'm not going to do my hourly rate here, but suffice it that it's significantly lower than even junior people at large law firms that have large amount of overhead and who are not accountable for results. But what the process looks like, it depends, of course, upon whether we're filing, what type of application we're filing, how many applications we are filing at once, and how many serial applications we are filing in the case of a foundational application. So, but the preliminary engagement, when you're going to sign up with me, we're going to sign up for 10 or 15 hours, depending on what it looks like. And there's two reasons for that. First of all, I need to be able to demonstrate to you as well as to myself that when we get together to do work, that I'm going to be able to deliver value to you. Okay, I'm not doing this just to deliver value to myself like I used to when I was a, quite frankly, did for myself when I was a law firm shareholder. I want to do this only if I'm creating demonstrable business value for those who hire me. And that takes me a few hours to figure out. You know, I got to do some background work and analysis, and you know, that characteristically takes 10 to 15 hours. But also, and I'll be quite candid here, I also need that time to figure out whether we're going to work well together, because if we're not going to have a good working relationship, collaboration, this takes collaboration. And if we're not going to be able to do that, I have to tell you, I'm not the right person for you. And you know, you may need to create business value from IP, but you're not going to be able to do it with me, because I cannot guarantee or even come close to guaranteeing that that this is going to be the result. But once we get past the preliminary engagement, what we're going to do is the application ideation and drafting. If it's a provisional, it's going to take me 15 to 40 hours, depending on how much work is involved, you know, what strategy we're undertaking. But you know, so at a minimum, hiring me to get a provisional patent application filing, you're in for 25 hours. More likely, it's headed toward the 30 level, and could even be higher, but I let you know that very in advance, because I've been done this enough times with not just the applications I showed you, but the many other applications that I've done in similar ways. If you're going to go directly to a utility drafting, we're looking at you know, in addition to the preliminary engagement, we're looking at 25 to 75 hours, and you know, that may look like a lot, but if you're thinking about carrying this application forward for several years, you know, you're looking at 2, 3, 4, 5 application potentially in the future. It actually distills out to be not very expensive per application, especially given, you know, if things work out the way that we intend for them to work out, that the amount of value that's created on the top end of that. Each claim set is going to be, you know, 5 to 15 hours, because you do the specification and the claims are a separate effort on each of the applications. And then when these go in the patent office, the patent examination process, I really need to handle that, at least at the high level, to make sure that the patent examiners' rejections are properly handled and the claims are not amended in a way that that reduce the amount of value associated with the overall patent application process. So I'm typically involved, but again, I'm effectively your in-house IP strategist, as if I was at a corporation, like I was, you know, when I worked for a large corporation. I handled a business and I knew what the business needed, and without my active involvement, outside counsel wouldn't know what the business needed. So I effectively take that strategy, that representation strategy, on a fractional basis for each of my clients. Now, if we go over this, now I'm not the only one who's got fees in this process, but I want to be full disclosure here. We have outside counsel. If we're just going to file a provisional, I can help you do that. It's very low fee. It's very easy to do. So there's no outside counsel, because remember, we're not filing the final application here. We're just filing the provisional. The utility application is we're going to have to bring outside counsel in. They need to get paid. They have the ecosystem, the infrastructure to handle and manage the process. And so we're looking at anywhere from $3,500 to $7,000 on that. I do negotiate lower rates with outside counsel just because I can. I know how much it should cost, and I'm not going to let my clients pay more. I'm going to push back. And I have to say, people really like working. The people who work for me as outside counsel, they actually like working for me because I see that they're making some real differences, and they have a different type of involvement with the patent application. So I am able to bring folks on that and to get them to bill me a lower rate than you working independently might not be able to do. We do have patent office filing fees, roughly $3,000 for a track one per application. and half of that if we're just doing a regular speed application. Patent examination process with outside counsel is $2,500 to $5,000 roughly. And then we got some additional fees for allowance. And then if we're going to file new patent claims, we have to just on additional patent filings, we have to go ahead and multiply or add those additional filings to these numbers. But the good news is that once you filed a patent application and got an allowance, the ones that come afterwards from the same family are typically easier. And so the costs get commensurately lower. One thing that differs in the track one versus the regular speed filing process is that you're front ending all of the patent examination fees into the first year, as opposed to amortizing it over 2 or 3 or 4 years, as you do in the regular filing. So it can add up really quickly. But because my clients have made the decision that the business case is that we need to accelerate these applications to achieve the desired business outcome, that extra cost is actually far outweighs the costs actually are better to be front ended, because we're going to make more money in the short term over that, I should say. Okay. So in closing, I just want to circle back around to what the first part of the conversation was. Patents rarely matter, but when they matter a lot. Okay. And I repeat that all the time to folks. And I only want to be involved in patents that are associated with meaningful innovation, and where we have determined that patents might matter a lot, because we have gone through the efforts of figuring out how that may be. The definition of strategy is defining an endpoint and working backwards. So in the context of patent strategy is, what is your business outcome and how do patents align with that? That's when, if that's important, that's when you want to bring somebody like me in to help you achieve that desired business outcome. So if you're ready to win at the patent game, feel free to reach out. I'm very specific and intentional about the clients that I take on, as should be apparent. But if you think that you are someone who might have a desired business outcome, a business strategy that mandates the types of proven results that I have been able to get from my clients over the last several years, please feel free to reach out. Is my contact information. I also, if you want more information, my podcast is Winning with Patents and IP, available on all the podcast platforms, as well as on my website, thehuttergroup.com. And I write a lot about this topic on LinkedIn, so you can reach out and take a look at the many things that I have written that might help you understand this process in more detail. Thank you very much. And I look forward to hearing from you if you're the right person.